allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do we have a motion to approve the agenda as presented? Mr. Nelson makes the motion. Mrs. King will second. All those in favor, please signify by saying aye. Aye. Motion passes and the agenda is approved. Next, we will conduct a training course as required by the West Virginia House Bill 2499. The course will include training on the Individuals with Disabilities Education Act of 2004, the least restrictive environment, updated discipline guidance, parental rights related to due process, teacher rights and responsibilities, and staffing considerations. It's required that we provide this training before December 31st this year. And your trainers are Superintendent April Hott and myself.
So in front of you, on the little tent that's in front of you, that is your agenda for this evening. We will be covering 8 topics, and that will help you keep track of where we are as we work through these parts of the training.
Ready to go?
Yes. Okay.
Yes. While we're getting ready, you have a pretest that is before you. So if you could just take a moment to look over your pretest and let us know your thoughts on those 10 questions, and we will go over it. Is it 10? Yep, 10 questions, and we'll go over it after we have completed our training. But just go ahead and take your little pretest.
This is going to show how badly we don't know before we're trained.
Yes, and then you're going to say, oh, look what they
And then you're going to see how much you improved during the training.
I don't want to take a test I know I'm going to fail.
Use a pencil then.
How to get retrained. Are you doing?
I don't think so. No.
Everybody needs some skill set. Did you take it before?
I don't have one.
I thought I gave you one.
You did.
Do you need a pencil, little girl?
I've got another one. I buy the sun pen at work.
Is there someone at the door, Simon? I think the newspaper's at the door. You see them?
See someone. There you go.
This was puzzling me.
Really, you just want
I'm
to
just
guess it?
guessing.
You already know them?
You have to think positive.
Okay, good job. Will you let us know when you're done with your pretest?
I love true and false. I get most of them right.
Half of them, right?
Yeah. So what if that's taking Miss Hall's class again? Coldest line was you, was a keyboard?
Middle school, high school.
Just back your fingers.
She can.
You're gonna teach him.
Between me and Sean Snyder
I
and.
don't remember.
You already recorded.
Poor thing.
I did my student teaching at Mystic.
Aw.
It's been a day or two ago. All right, as we finish up with this, I will let you know that we are having a board meeting tonight. It is being recorded. This is December 1st, and we are meeting the requirements of House Bill 2499.
It is a training navigating special ed regulations. Dr. Jackson and myself will do this training this evening, and we do have Sonia Hott with us, who is our new Director of Student Support Services, who part of her job is to oversee special ed regulations. If we don't know an answer to a question tonight, if you have those as we move along, Sonia will be here to help us find that answer to make sure that we provide you good information. But as you know, Sonia also is in her first year in this job and is doing a great job and learning tons. So she's here tonight in support of us as well. On the front of this page, your front sheet, you do have two QR codes. The QR codes represent 18A-3-13, 1820-1C, which are state codes and are reference codes for the training that we're providing you today.
Okay, so this training that we're providing today is designed for principals, central office personnel, superintendents, and all Board of Education members in the state. It must be completed by December 31st, and our goal is very simple. We want to ensure that all eligible students with exceptionalities in West Virginia receive a free, appropriate public education known as FAPE.
As I mentioned earlier in front of you,
Make sure that's on. Don't hear it over any
Like that.
speakers.
I think this keeps going on.
Or you take Misty's mic a little closer to you. I just didn't hear it over the speaker.
thank you. Hello, is that better?
It's not working?
Is this one working?
Hello.
I don't think it is. We will speak very loudly.
Okay.
You guys can move up to the other two chairs too.
Mine's on, I
It's
just
still.
usually hear it a little better.
Yeah, you can usually hear it.
Especially if I have mics used, that's all.
Give us just a second for technical difficulties.
Shows it's on.
It might be working fine.
And it may be that I didn't turn something on, I believe Teresa knows how to turn on.
Hello, hello, hello.
Hello? Hello?
Maybe through the speaker, overhead speakers or something. It's working fine.
Now try it, Tori.
Hello? Hello? Ooh.
Well, this one, hello, that works. Very, very good. We're all very friendly. Hello, everyone. How are you doing today?
Now we're set.
Okay.
Again, in front of you, you have a list of topics that we will cover today. There are 8 of them that we will cover, and you have it on the little TP in front of you as the agenda. Foundations of Special Education Law, Understanding the Least Restrictive Environment, Discipline Procedures and Requirements, Parental Rights and Due Process Safeguards, Staffing and Classroom Considerations, Teachers' Rights, Responsibilities, and Protections, IEP Meeting Format and Advocacy Information, Principal and LEA Board Member Responsibilities for Informing Teachers.
So we're gonna go through these one by one, and at the end of each section, we will stop and allow you to ask questions. So we're gonna start with number 1, which is Foundations of Special Education Law. The core principle for it is understanding these foundational laws is crucial for upholding the rights of students, parents, and school personnel.
As we mentioned earlier, one of the foundations of law is the Individuals with Disabilities Education Improvement Act of 2004. One of the things you will see throughout this whole thing, you've already heard so far, there are a lot of little like IDEA, FAPE, you're gonna see many of those. So if we're going through it and you go, oh, what was that, I forget, please make sure you ask. But IDEA, which is the Individuals with Disabilities Education Improvement Act. It's a federal law ensuring all children with disabilities, and they're called CWDs, receive FAPE, which you heard earlier is a free and appropriate education, tailored to their unique needs for future education, employment, and independent living. protects the rights of CWDs and their parents and applies to all public agencies receiving Part B funding. The next one is eligibility for assistance. A state qualifies for that Part B funding if it assures the secretary that policies and procedures meeting IDEA requirements are in place. West Virginia meets these requirements through what we call West Virginia Policy 2419.
All right, when we look at West Virginia Policy 2419, it is known as the Regulations for the Education of Students with Exceptionalities. Notice this is a legislative rule, and it is for those aged 3 to 21. I didn't know many years ago that you could still go to school up to 21, but you can if you meet the exceptionalities. And it defines the responsibilities of the state and also local educational agencies, which are called LEAs, in complying with IDEA. So if you do look at number 1 on your quiz, I think we've talked about IDEA multiple times, and it may help you with that first question on your quiz. So also we're going to talk about something called state educational agencies, which is called C, and that agency is responsible for the state supervision of public elementary schools and secondary schools, which is the West Virginia BE and the West Virginia DE. How do you like initials? And so we're going to ensure that all IDEA requirements are followed for programs serving all of the initials.
Children
And the children.
The local educational agency, which is the LEA, includes county boards of education, school facilities under the West Virginia Board of Education supervision, charter public schools responsible for providing quality educational services. FAPE, free, appropriate, public education, special education and related services provided at public expense under public supervision without charge, meeting state standards and in conformity with an IEP or individualized education plan.
So one of the things that's impacted by this new legislation is IEPs and students who get disciplinary action and are on an IEP. So it's important that we understand that there's new things that we have to determine if a student is on an IEP and they get in trouble. So an IEP, again, is a written plan for an eligible student with an exceptionality developed collaboratively by a team including parents and educators. It outlines the student's unique needs and special education services required to meet those needs, enabling them to have progress in the general curriculum. It must be reasonably calculated to enable a child is able to make appropriate progress in light of their circumstances, and it has to be appropriately ambitious. Do you have any questions about the foundations of special education law? Okay, then we're going to move on to number 2.
Number 2 is understanding the LRE, which is the least restrictive environment. And the core principle for that is an eligible student must be educated with general education students in the general education classroom to the maximum extent appropriate, i.e. the least restrictive environment.
So we're going to look at a chart, and we're going to try and understand what this least restrictive environment is. So first, when do we remove from general ed? We do this only when the nature or severity of the exceptionality means that education in general classes cannot be achieved satisfactorily, even with supplemental aids and services. And it also matters if the IEP must explain any non-participation in the general education classroom curriculum or non-academic activities, including the percentage of time in general and special education. So they are calculating all of that when a student is on an IEP.
One of the nice things that we have been provided through this department at the State Department is a very good, like a flow chart when we start looking at a placement decision. And it helps you remember to start with general ed and going from there. But the placement decision made individually for each student based on the unique needs not on disability categories or available options. Students, or should be, as close as possible to the child's home. Students not removed from age-appropriate general education classrooms solely due to the needed accommodations. IEP team begins its placement decisions with the general education environment with supplementary aids and services.
All right, so if you look at number 2 on your quiz, as we go along, your pretest I should say, you should now be able to answer who determines the student's least restrictive environment. Does anybody want to take a guess? Very good, Mr. Reed. It is IEP team. So we are next going to understand the least restrictive environment. We have to make sure that we're doing a few things on our side to make sure that we're following the regulations. One is we have to have a continuum of services. So this LEA must ensure a range of settings are available, including instruction in regular classes, special schools, home instruction, and hospitals, institutions with provision for supplementary services. So whatever is required to make sure that this student is still educated is something that we are required to do. There have to be opportunities for non-academic and extracurricular services, so we must ensure equal opportunity for students with disabilities to participate, provide supplementary aids and services as determined by the IEP team. So this means things could be meals, recess, field trips, athletics, all of these have to have equal opportunity. And then there's an opportunity for co-teaching, which allows students who need significant accommodations to remain in the least restrictive environment alongside their peers. So I believe we could describe this as an aide who will be there or not.
So a lot of times when you talk about co-teaching, it's actually if I need an additional support in an English classroom, there's often a special ed teacher that goes in and does planning, as well as oftentimes pre-teaching with students before they go into the regular classroom. So most often, the co-teaching component is with another teacher.
Okay.
You get support from aides as well, especially in the lower grades, but your main inclusion, it's called inclusion, or your co-teaching comes from a certified teacher, hopefully.
Great, and then we have to make sure that there are benefits for students with disabilities so they receive targeted support without being removed from the general education classrooms. So we need to make sure that we're promoting social integration, access to grade level curriculum, and more inclusive education.
So on the next chart, you will see that it's broken down by age group. On the left, it is early childhood, ages 3 through 5, and we're talking pre-K students. When you're pre-K students and you're looking at least restrictive environment, you have the regular early childhood program, which is the classroom they're in. You have special education classes, separate schools, residential facilities, home, and service provider locations. When you start looking at school-age students, 6 through 21, and 5-year-olds that are in kindergarten, not pre-K, you are looking at general education full-time, which is called GEFT, general education part-time, which is GEPT, separate classes, special schools, out-of-school environment, residential facilities, parentally placed in private school or correctional facilities.
So at the conclusion of number 2, do you have any questions, and are you now able to answer pretest number 3? You have a question.
Just because I've lived this. I'm just curious, what would be the process you think that a parent should go about if you're told that your child's not allowed to go and you're denied by your principal?
For an IEP?
For a field trip.
I think that has a lot of different angles, but as far as special needs kids, see, you're asking the wrong person because I'm not sure I think anybody should be excluded from field trips. So.
Well, I know,
So I think that
I
think that the kid has to be in their least restrictive environment, and if that is their least restrictive environment, they may have to have additional support to be able to take them. It may require potentially some parent support or additional school staff in order to, but the goal is to make sure that all students have a free and an appropriate education, and that they reach FAPE, which
This
also
applies
includes
to
that.
all counties in
Yes.
West Virginia.
Yes.
I would say that if there has been a decision at a school that wants to be appealed, I think the first step would be to the director.
But I think when a lot of times with special ed, and they'll tell you, or in education in general, it's, you don't know everything, so it's hard to answer it flat out, because you don't know if it's a medical issue, someone can't go, you may see it and think, well, this is the reason that kid's not going is this, it may not be that at all.
Right.
And so, I think that if a parent would have a concern, there's always a place to start. Start with the principal and then go to you.
You trust that your principal is gonna tell you
Yes.
the truth
Mhm.
or whatever, but I just wanted to know the
Yes.
next chain of command, just for.
The thing that they said at the meeting was that the school should make sure that when they're picking out the field trips, that it's one that all students could go and have access to and be able to enjoy. It shouldn't be a
Good.
real specific type that is going to leave out the interest of most of the students. So I think when we're looking at field trips too, it needs to be one that the majority of students would enjoy and have access to get to.
Right, do we have an answer for number 3? C, very good. Maintaining student access to the general curriculum. Thank you for agreeing to.
I have a question.
Yes, sir.
What if the parents, and along with the teacher, want to kind of bypass the least restrictive environment and have a separate class with a smaller group of kids because they feel like their child or the other kids would do better?
You take that.
I believe that goes against the policy.
But, okay, but. you
And
have
I
to
think we have to be careful when you talk about IEPs, that you don't, we are not an IEP team. And so what you have to make sure of is when you get an IEP team together, that they start through that process of starting with general ed. And you'll see later in this as well, it talks about that relationship with parents and making sure that, one, as a group, we come up with what's best for the child. And two, that we don't give too much. I mean, I won't say don't give too much, that's the wrong thing. That we together as a group make sure that we make the right decisions for the right reasons, not because, like they said earlier, because of there's not enough room in that classroom, or that you have to, as a team, understand that child's need. And you have to keep circling back to what's best for that child, not in general statements. In special ed, you can't just make general statements.
So it's the reason why number 2 says that the LRE is determined by the team and not by a parent, and not by a special ed director.
The team makes the
Because
decision.
there could be cases. I think
There
there
can
have-
always be exceptions.
But they would need the data to support why that position would be the best place for that student.
Right.
And then they would discuss it.
And, okay, but I'm just picturing like a good relationship with a teacher, and you've got a small group of boys that like hunting, and those students are gonna relate to that teacher to get more academic results from them, and maybe better behavior, but you're not isolating them totally, because you do have your own classroom with students in it.
So again, that would be determined by the IEP team.
But could they
At the
determine
start.
that? Could they write that in the IEP?
Right, what?
That we're gonna have a class, a smaller class with these 5 boys?
You can write for services, but you cannot write for particular people. Because if that teacher would move, or if that teacher would leave, or if some of them students would move, then you wrote that for people and not for something that was really going to help the student. So the answer would be no, you have to write it for the actual service that would help the student.
Right, okay. All right, thanks.
Okay, so next we're moving on to number 3, and number 3 is discipline procedures and requirements, and the core principle is that students with disabilities are afforded special protections and procedures regarding disciplinary actions under IDEA, in addition to general due process rights.
Preventive discipline. LEAs must implement a preventive discipline program with a tiered system of support using positive intervention and supports called PBIS. If a student's behavior impedes learning, the IEP team must consider and include positive interventions in the IEP if needed. And one of the things we did this fall, to start school out, was to have a training on CHAMPS. CHAMPS goes hand in hand with student behavior and how to manage kids in the schools as well as in classrooms. So you'll have different programs that support student behavior in the general population and with all students.
So next we define protected students. So protections apply to students with disabilities and those not yet eligible if the LEA had knowledge of a disability before the disciplinary behavior occurred. So examples would be if parents or adults, students express concerns in writing about the need for special education, or if a request a special education evaluation in writing, or if teachers or other personnel have expressed concern about a pattern of behavior demonstrated by the student to supervisory leadership in accordance with the district's established child find system and referral process. Also, it will apply if an evaluation request is made during disciplinary action. And protections do not apply to students solely categorized as gifted or where there is no basis for knowledge because an evaluation found no disability, parent adult students did not consent to evaluation, or parent adult students refused special education services.
Disciplinary removal includes out-of-school suspension, expulsion, interim alternative education settings. In-school suspension is generally not a removal if the student continues to participate in the general curriculum and receive IEP services. A few facts. School personnel can remove a student for up to 10 consecutive or cumulative school days. Services are not required during these initial 10 unless provided to non-disabled students. After 10 days, during any subsequent removal, the LEA must provide services to enable participation in the general education curriculum and progress toward the IEP goals. A bus suspension is a disciplinary removal if the student's transportation is part of the IEP. Even if the student can still physically get to school by other means, denying the student special transportation services is considered a denial of special ed services.
There's a lot to the discipline section, so moving on to disciplinary change of placement. This occurs when a student is removed for more than 10 consecutive school days, or a series of removals totaling more than 10 cumulative days shows a pattern of similar behavior. It also can mean additional factors such as the length of each removal, the total time removed, and the proximity of removals to one another are also considered in determining a pattern.
In the discipline of a student that meet the requirements that Dr. Jackson spoke about prior, it requires a manifestation of determination review, which is called an MDR. Required within the 10-day suspension of any decision to change placement due to disciplinary reasons beyond the 10 consecutive or cumulative days, we must have what's called a manifestation determination review. The IEP determines if the behavior was caused by or had a direct and substantial relationship to the student's disability and or a direct result of the LEA's failure to implement the IEP. If yes, a functional behavior assessment, an FBA, must be conducted if not already done. A behavior intervention plan must be developed and reviewed. The student returns to the original placement unless the special circumstances apply or agreed upon. If no, school personnel may apply disciplinary procedures as for the students without disabilities. However, the IEP team must still determine needed educational services to continue general education participation in the IEP goal progress, even in another setting. An FBA and a BIP should be provided as appropriate.
And now you should be able to answer number 4 on your pretest. What happens if the manifestation determination review team determines the behavior is a manifestation of the student's disability? C, Mr. Hall is correct. The student is returned to their original placement with necessary support. You guys are doing great. Very proud of you.
You knew all that too before we went over.
All right, we are gonna talk about special circumstances and did you have a question?
Yeah, because I'm not,
Go ahead.
not a teacher or not in education, but so like, let's say an IEP is for dyslexia learning, and the problem was the student acted out and struck a teacher. So that's not part of their IEP, is that what you're saying? So that wouldn't place them back in their original placement. You would deal with that differently, right?
The manifestation determines whether or not the behavior had a link to their disability.
It's a very good question.
Okay.
And you gave a good example.
Yeah.
That was a good example.
So for special circumstances, we look at weapons, illegal drugs, and serious bodily injury. School personnel may remove a student to an LEA for up to 45 school days, regardless of manifestation status, if the student engages in these specific behaviors. So weapon, illegal drug, or serious bodily injury, and those are explained for you. In an LEA, the student must continue to receive educational services to participate in the general education curriculum and continue to progress toward IEP goals. This is one of the areas that will still come before the board for disciplinary hearings from time to time. And so make sure you understand that piece. Does anybody have any questions about it?
You can ask for an IEP meeting to kind of make it go faster through the process. And it can be requested if the parent, the adult student disagree with the MDR, which is the manifestation, or disciplinary placement, or if the LEA believes believes maintaining current placement is substantially likely to result in injury. This complaint is assigned to a hearing officer. So as it escalates and there are additional issues or additional problems, there are different steps that we must follow, or can follow.
Are there any questions about discipline?
Who's our hearing officer?
You want to answer that?
Hearing officer.
They said it would be assigned to us, so
Outside?
it would be an outside person. So hopefully we don't ever know. So far we don't know, or I don't know.
Some good.
All right, next we're going to go to parental rights and due process safeguards, which is number 4, core principle. These safeguards ensure parents and adult students are fully informed and have the opportunity to participate in decisions regarding identification, evaluation, educational placement, and FAPE. Does anybody remember what FAPE is?
They didn't.
They didn't. I'm going back. Free appropriate public education.
Parental rights, there are notice requirements. Procedural safeguard notices, a comprehensive document explaining safeguards provided annually, update upon initial referral evaluation request, upon the first state due process complaint or disciplinary removal causing a change of placement. There's a paper about special ed that we have to provide them, and it is called a procedural safeguard. Prior written notice, you'll see that a lot. It's the PWNs. It's given to a parent, adult, student, a reasonable time, 5 days in West Virginia, before the LEA proposes or refuses to initiate or change identification, evaluation, placement, or FAPE. For disciplinary removals, the PWN must be provided on the same day. Notice of meetings. Parents, adult students must be notified early enough, no less than 8 days prior unless waived by a parent, for eligibility committee and IEP team meeting, and must include the purpose, time, location, and attendees for the meeting.
parental participation, we must ensure that parents can meaningfully participate. So we have to offer flexible scheduling and alternative methods, whether that's a video or a phone call. And we have to provide interpreters for anyone has a hearing impairment or whose native language is not English. There also is a factor of consent. We have to have informed written consent is required for initial evaluation and initially providing special education and related service. Informed written consent is required for reevaluations with exceptions, and consent must be voluntary and cannot be revoked in writing. If revoked for continuing services, the LEA cannot continue services and is not in violation of FAPE. What's FAPE?
Free and
Free appropriate public education, is that correct?
Appropriate.
Okay. And then we have independent educational evaluation. Parents and adults can obtain an independent evaluation at the public expense if they disagree with the LEA evaluation. LEAs must consider the results of the independent educational evaluation if they meet agency criteria.
Sometimes in cases with students, there are surrogate parents assigned by the LEA to represent a student's rights when a parent cannot be identified or found. The student is in the ward of the state or unaccompanied homeless youth. Adult students, this was interesting, and I think that I checked to make sure we're doing this because we were with some special ed teachers that day. In West Virginia, at the age of 18, all rights under IDA Part B transfer to the student unless a legal guardian is appointed. An IET must discuss this transfer by the student's 17th birthday. Both the adult student and parents receive notice, but only the adult student makes decisions unless a guardian is court approved.
For dispute resolution, there are several options. These include a facilitated IEP team meeting, which is voluntary impartial facilitator that guides the IEP process. There can be a state complaint, which an individual or an organization can file a written complaint with the West Virginia Department of Education alleging violations of special education laws, and that's within prior 1 year period. There can be mediation, which is voluntary confidential process with an impartial third party. There also can be a due process complaint, formal process to resolve disputes concerning IEPs or FAPE, and they must be initiated within 2 years. So we have some facts. Fact 1, unresolved disputes can delay services, harm progress, and damage relationships between families and schools. Fact 2, avoiding formal resolution may lead to costly legal action and reduce trust and collaboration. Fact 3, giving in to unreasonable requests can create unrealistic expectations and strain resources. And fact 4, proactive dispute resolution promotes timely, fair outcomes and supports positive partnerships focused on the student's success. So, knowing what you now know, look at number 5. Which of the following is not a parental right under IDEA? Mr. Hall says C, and that is correct. And the answer that is not a parental right is to determine the child's least restrictive environment. Who makes that determination? The answer is in number 2, the IEP team.
And Mr. Nestor, earlier when you asked that question, this was the slide I was referring to in my mind, is the facts down here below, that one of the things that we have to always understand is when we're working with an IEP team, that we're in this together, and that we are looking at what's in the best interest of the child. Then we start with the general education, because if we go off that track, then we have to figure out a way to, I mean, if a kid enters in an IEP in kindergarten, they're in 12th grade and we need a relationship with that parent. And so I think that's the part I was trying to say earlier is the better we communicate, the better we follow the rules that are set in front of us, the more successful it will be for these students if we make sure that we have their IEPs accurate.
Now I've got a question sort of about that, and I think this has happened. What if neither parent will sign for any kind of help? I mean, they just feel like, my child's not gonna be in there.
You have to have consent.
And so that, we can't really, like elementary student, you can't,
There has to be consent or you cannot start the services.
so they could go to like Title I without.
Title I.
Without.
And
And I think that the tiered level of support for academics
Yes.
greatly helps with that, because we have a lot of programs in place that support children, that do have
Right.
academic needs as well.
Because it has happened, parents did not want to have them tested.
Any other questions about number 4? Moving on to number 5, staffing and classroom considerations. The core principle is ensuring appropriate staffing and class composition to meet diverse student needs and maximize educational outcomes. And in West Virginia pre-K classrooms, there's a maximum of 20 students per classroom with a limit of 10 students with IEPs. The staffing varies by the number of students with the IEPs, and there's an example. But if you look at number 6 on your pretest, you should now be able to answer it. You will have to do a tiny little bit of math. Yes, sir.
Inappropriate training for the question. If you only had 10, it says you have a limit of 10 of IEPs, so actually 100%.
The maximum allowable amount.
But it doesn't say ratio, so
He's questioning our question.
it just says limit of 20 students, limit of 10 students with IEPs. But if you only had 10 students, I'm just saying.
Yes.
What percentage would you get though, if you had 20 students and 10 of them had an IEP?
Training doesn't say ratio.
Would you just tell me a percentage?
Okay, you are right, but.
So what it's telling you is up to 50% of a pre-K class can have IEPs, but no more than 50% of the class can have IEPs.
I thought maybe because all preschool teachers have to have their master's in special ed services, that they could even go higher.
I do not believe that that is what
I know,
this training
I
is
know,
telling us.
But you can't teach preschool unless you
Correct.
have the special ed.
But what they're saying is there has to be more than one adult.
Yeah.
Right.
Well, what if there's what if the teacher has 2 A's because of the number of students?
Well,
That doesn't work.
so if you read,
So the example, read the example there.
Yeah, go ahead.
Okay.
If you have 2 staff for up to 8 IEPs, you would have 3 staff for 9 to 10 IEP students.
Oh,
So
okay.
there is a ratio that exists inside the percentage.
All right.
Just saying.
So the reason they wouldn't go above 50% is because they want them in the general ed population, and if it's over 50%, then it wouldn't be a general ed
Considered,
classroom.
special
It'd be a
ed.
special ed classroom.
Good answer.
And then
That's
you're
why
limiting
Sonia's
the
here.
spatial interaction.
Very good, Tanya.
That's why Sonia's here, by the way.
Staffing and classroom considerations. This is for grades K through 12. And on this, it talks about staffing ratios vary by service level needs, whether a student's level of need is a level 1, 2, or 3. And then it depends based on grade level. For an example, if I'm a level 1 student, then I'm in grades K through 2, then my ratio is 1 teacher per 6 kids. If I'm in grades 3 through 5, it's 1 to 8 with a maximum of 12 students. If I'm a level 2, then your ratios are there for all grade levels is 1 to 6, a maximum of 12 students. And level 3 is 1 to 4 for all grade levels, a maximum of 8 students. So you can see how that changes, depends on the level of need of the students. The next one is, and the reason this is important to you all, when we come to you and say, we need to hire another special ed teacher, we need to hire, it's because we have ratios that we have to meet. And so we're not just coming saying, hey, we need another teacher. It's because at some point we've reached a number that we no longer can function within the laws. And so we continually monitor that in our schools as do, and especially at this time of year when we're starting to look at schedules for next year, that's a big focus. The next one is staffing and classroom considerations, maximum number of students per instructional period based on the level of service. Again, you have level 1, 2, and 3 down the side, and this has it broken down for K-5 students, 6, 8 students, and 9, 12 students. And it just shows you the maximum. For an example, if I'm a level 3, the maximum in high school 9 through 12 is 8 students with a minimum staffing ratio of 1 to 4. So if you had 8, you'd have to have 2 people in the room. So that just gives you, we have these charts that we use to make sure that we follow the ratio of required staff for students. Temporary waivers and teacher compensation. It is in West Virginia Code 1820-17. A 2-week waiver is possible if ratios are exceeded, during which the district compensates the teacher. If a teacher isn't found after 2 weeks, a waiver extension can be sought with the teacher's agreement. A county cannot exceed the student limit by more than 3 students, even with additional teacher pay. Waiver request. If students' number exceeds established staffing ratios, LEAs must add staff or submit a written waiver request to the West Virginia Department of Ed. Waivers are considered case by case, valid for the current school year only, and must include the teacher's signature. So basically they're saying you can't overload a class, you have to fall within these limits.
Any questions about number 5? Moving on to number 6 is teachers' rights, responsibilities, and protections. The core principle is noted in Code 1820-1C and Policy 2419, and it outlines rights, responsibilities, and protections for general education classroom teachers when serving students with exceptional needs.
In teachers' rights and responsibilities, there are some areas we will cover with you. First, training. Teachers are entitled to training to meet student needs, ideally before placement or within 10 days of placement if prior training is not possible. IEP information. Teachers must receive a copy of a student's IEP prior to or at the time of placement. In the state of West Virginia, we have what's called Read IEP. If a student is on my class list, then I have access to go into an app, which is part of WeList, that allows me to read that student's IEP. So we check annually at the beginning of the year as students move in to make sure teachers that have these students in class have access, and it marks that they have indeed read the IEPs. When possible, referring and receiving teachers shall participate in relevant eligibility and IEP committees by attending the meeting or providing a classroom teacher report. Requesting an IEP meeting. Teachers can reconvene the IEP committee if after 45 days data indicates a student is not in their least restrictive environment for academic growth. A teacher can request an IEP meeting, which must be held within 21 days. Rights to advocate without repercussions. Teachers cannot be penalized for advocating for their students. This includes collaborating with families, sharing documentation, recommending local advocacy groups, informing families of due process rights, and requesting IEP meetings. Assistance. Teachers are entitled to assistance from trained or certified persons when it is part of the student's IEP as necessary to promote accomplishment of the program's goals and objectives.
And lastly, in this section, we have teacher responsibilities for the IEP participation and acknowledgement. So they don't have to go to the meeting, but they have to sign a copy of the student's IEP acknowledging that they have read and understand it. They also have accommodations and modifications. So they have to document appropriate accommodations are being met. General ed teachers are not responsible for daily accommodation logs. They're responsible for acknowledging that each required accommodation has been met at the end of the grading period. However, parents can request daily accommodation logs. And a teacher has 45-day grading period in which they can gather evidence to determine if the student is in the least restrictive environment, and then they can ask for an IEP meeting if they believe that they are not in the least restrictive environment. And finally, they will have data for placement, so the IEP must include data to support placement decisions. So if you will look at your pre-test number 7, the answer is C. Thank you. Keeping a daily
5
log.
C's in a row.
I know.
We see that.
We did not create the pre-test, just for the record. Any questions about number? Yes, we did. Any questions about teacher rights and responsibilities and protections? And we are moving on.
IEP meeting format and advocacy information requirement. In every IEP meeting, a school representative shall verbally explain to the parents the following. And in front of you, you have a form that's on like a heavier paper. It looks like this. This is the new document that they are required to go over at an IEP meeting.
Great, at the top of it says House Bill 2499, verbal explanations for IEP meetings. This is to be reviewed at every IEP meeting with the parents. It has the student identification process, the parent guardian's due process rights, the teacher protections and procedural rights, and information and contact points for local advocacy centers.
And then the last one is number 8, principals and LE8 board member responsibilities for informing teachers. Requirement, each principal and county board member shall inform teachers in person of their rights, including but not limited to the following. The documentation process within a 45-day grading period for teachers, the rights of teachers when it comes to informing parents of local advocacies who can come to individualized IEP program meetings, protection methods in place for teachers who advocate for student placement, and all teacher protection and rights set forth under 1820-1C.
So we are able to answer number 8, it's true or false. Mr. Reed, you really like true or false, so you go with true or false?
True.
True. True is correct. In every IEP team meeting, a school representative must provide written documentation, and again, you have an example of that in front of you. And then number 9, I believe you can also answer, each principal and LEA board member shall inform teachers in person of their rights.
True.
True, it's also true. Very good. College, so smart. So.
You can use one of mine.
I always wanna hear- yeah.
So we're going to talk about IDEA funding and C assurances. When accepting federal IDEA Part B funds, the SIA must, or I think it's just C, must sign assurances confirming compliance. Yes, with IDEA requirements and federal regulations. A state qualifies for Part B funding if it assures the Secretary that policies and procedures are in place. Any state policies or expenditures beyond IDEA cannot be funded with federal dollars, and failure to comply with these assurances may result in withholding or the loss of federal funds. And the final question that we have for you is advocacy is a key component of House Bill 2499, including teachers' rights to advocate for students, protection against being reprimanded for advocating for students, and the provision of information related to local advocacy agencies and United States Department of Education funded advocacy agencies to parents, teachers, and local educational agency staff. Is it true or false?
Yay.
True.
True. Very
Trying to
good.
get that to be right.
So this evening, as we have reviewed the training that is required for House Bill 2499, we have gone over, as you look on your agenda, the 8 items in front of you, and hopefully, when we do a training in our county, we always hope when we start that you at least walk away knowing one more thing than you did when you got here. So we hope that is the case here today, that we taking this time and reviewing this information. Mrs. Hott and I are working on the plan to move this forward because we do also have to provide this training. We at this point have it scheduled to present to our directors on the 17th and the principals. That meets the requirement for the December 31st, what we have to have done by then. And at that point, then we move on and look at our next steps in making sure we took a small group with us the other day that got some training. So we'll do some train the trainers, but we will have a plan in place to make sure that we meet all expectations of this House bill.
And for extra credit, what does FAPE mean?
Free appropriate education.
Free appropriate public education. They got it as a group. They got it. Way to go, guys.
Is that a plus 10 or
So,
what?
plus
'Cause I
5.
scored an 80. So 85.
You have a question?
You get extra
He
credit.
has a question.
It's for Sonia, right?
Maybe. So we learned a lot about teachers' rights, their responsibilities, their participation in them. What about the aides, like that are in grades up through 3rd grade? some conversations where aides may not be ready or willing or trained to handle what's needed to be handled, I guess, with children with IEPs. What is there for them?
So, yes, but what you have to understand in education, I guess the easiest way to explain the role of an aide is if you look at a doctor and I'm a physician's assistant and I work under your license. If I'm a classroom teacher, the aide is actually working under my license. They're part of my extension. So as a teacher, it is a lot of your responsibility in involving that aide and educating them in what they need to know.
Yeah.
With that said, we also, under Sonia's direction, we also have offered some extra trainings for aides, and I think that question's a good question across the state of West Virginia because we have all these aides now,
Yeah.
and they're in different grade levels. And to make sure that we're getting from them and that we are protecting them and that they have an understanding of students, I think that as a county, you will see us coming to you saying, hey, we're gonna run this extra training for aides, and you'll understand the reason why. Because their roles have changed through the years. There was a time okay, now I'll sound old. There was a time back in the day that, an aide they were grading papers or that's not what you see today when you're in classrooms. The aides are actively involved in the education and working with children directly, and they have a significant role. And I think that's wonderful that it's changed and gone in that direction, but it also requires us to acknowledge that and make sure that we do provide them the needed training.
Yeah, because they would need to know all of this.
Yes.
So they don't do something wrong.
Absolutely, we agree with you. And I think when we do the training, I think that when you do this training, there are a lot of your service personnel need to hear this because it involves buses and involves different things. And so when we're getting ready to do a training for special ed that we have to do every 3 years. It is required for all staff to have it. So I think that what you're saying is accurate, that this does benefit all employees. Do you want to add anything to that?
And the last couple textbook adoptions that we've had the aides trained as well because they are now an integrated part of that curriculum. So they are not being pulled to separate trainings, they are going in with the teachers more. So that's kind of going on that perspective too, that they need to learn the curriculum side, but they do need to learn like the behavioral side as well.
And I hear him saying they need to understand the legal side. What are our responsibilities as far as IDEA?
Yeah.
Yes. So with that said, we appreciate your time. Dr. Jackson, do you have anything else you'd like to add?
No?
I have a question for Sonia. Do you ever get a headache trying to keep up with all this?
Oh, I've learned so much.
Jeez.
All right, any further questions or comments from our board members? Our next regular meeting will be held December 8th at 6 o'clock here at the board office. The time is 6:58. Do we have a motion to adjourn? Mr. Reed makes a motion, Mr. Hall will second. All those in favor, please signify by saying aye.
Aye.
We are adjourned.
True or false? True.